one sec. Good afternoon and welcome. My name is Nilanjan Sarkar, and I'm Deputy Director of the LSE South Asia Centre here at the London School of Economics. I'm delighted to welcome all of you to this afternoon's event, the first in our newly named autumn term. We used to call it Michaelmas term till last year, and also the first in our Fact and Fiction series for this academic year 2023-24. The book that is going to be discussed today, Competition Law in South Asia, was published earlier this year and is authored by Dr. Amber Darr, whom I will introduce shortly. But before that, I did want to say a very, very warm welcome, not only to our panelists who have joined us quite literally from across the globe, but also to members of our audience who have joined us from various places. I want to begin by thanking everyone who signed up formally for the event, because it is very reassuring for us that there is so much of interest, and this is the reason why we do these events. So thank you very much. Thank you also for signing up. Those of you who are in the Southern Hemisphere, I mean, it must be crazy o'clock for you at the moment. So thank you very much for that as well. The event itself is happening via Zoom and is being live streamed on YouTube, and you will see that the chat function has been enabled. And please do ask questions via the chat function. Please type the questions over there, and I will pose them to panelists at irregular intervals once they have made their initial remarks and we are into the discussion. You, as members of the audience, you are welcome to pose questions to individual panelists, in which case, please mention the name of the panelist. You're equally welcome to pose a question to the entire panel, and we will pose the question to the panel, and everyone will have an opportunity to reply to that. Now, had this event been on site at LSE, LSE's regulations are that members of the audience are allowed to pose questions at public events without revealing their identity. To try and stay as close to that spirit, when I do pose questions that may have been submitted by members of the audience, I will not be taking the names of those members of the audience, even though your names are going to be visible on YouTube, unless you have registered into YouTube under some sort of pseudonym or through initials or something of that sort. But I won't be actually announcing the names of members of the audience. If you would like to tweet, then please do tweet and tag us at SAsiaLSC, and we will be very happy to see your comments. Now, I'm not going to say too much about the event per se, but it is now my very pleasant task to introduce the speakers. We've had a brief conversation before we came live on air, the order in which speakers will speak, and that's the order in which I will introduce all of them. And all panelists have been asked to make initial comments for about 6 to 8 minutes, after which we will start with the discussion. And your questions, at whichever time, will be posed during that discussion period. Dr. Amber Darr is lecturer in competition law at the University of Manchester and is the author of Competition Law in South Asia, Policy, Diffusion and Transfer, which was published earlier this year, as I mentioned, and is the focus of the discussion this afternoon. Dhanendra Kumar was the founding chairperson of Competition Commission of India and is currently chairman of Competition Advisory Services India, acronymed as COMPAD. Dr. Joseph Wilson is a founding member and then chairman of the Competition Commission of Pakistan, a barrister and solicitor, and currently adjunct faculty member at McGill University in Canada. Hassan Qaqaya is an LSE alumnus. We never forget to say this. So the first thing is Hassan Qaqaya is an LSE alumnus, currently senior fellow at the University of Melbourne, and was until recently head of UNCTAD Competition and Consumer Policies branch in Geneva. Eleanor Fox is Walter J. Derenberg Professor Emerita of Trade Regulation at NYU School of Law, New York. Dina Wakid is going to be the discussant and is professor at Sciences Po Law School in Paris. And Dina's expertise includes comparative competition law, antitrust, and regulation, amongst other themes. Everyone, welcome to this afternoon's event. I'm now going to invite Amber to make a presentation for her book, which will be between 10 and 12 minutes, and Amber will show one slide. Amber, please speak now.
Good afternoon, and I just want to begin with a very, very heartfelt thank you to the LSE South Asia Center for organizing this event, and of course for all the panelists for making time to be here. And I'm particularly appreciative because I know that you've all joined in from different places. I could not have imagined a more stellar cast to have this conversation with, so thank you very much for being here. So without further ado, the book, which is the subject of this discussion. The book is born out of my PhD research in which I'd looked into the divergence in competition enforcement in India and Pakistan. And I found that in part, it could be explained by the very different mechanisms and institutions through which the two countries adopted their competition laws. For instance, India had engaged in relatively more bottom-up, participatory, inclusive processes, and it had socialized its Competition Act for her context, whereas Pakistan had largely been coerced, if that's a state-of-the-art term, by multilateral agencies into adopting its competition legislation, and had employed largely top-down and exclusive institutions to do so. And I can expand on this further in the discussion. So this research had made me particularly curious about the rest of the South Asian region, particularly because I noticed that between 2002 and 2020, the remaining 6 South Asian countries, including the war-weary Afghanistan, had engaged with competition laws and policy through different strategies and institutions. But interestingly, none of them had progressed to the enforcement stage. So to explore, the book really was an exploration of what I refer to as the story of competition law, and it is a story in 9 chapters. It examines how competition laws came to be adopted in the 8 South Asian countries. To this end, it looks into their pre-existing legal and political context in which these laws germinated, the mechanisms and institutions through which each country engaged with these competition laws, and then, of course, the state in which these laws are at present. So the aim of the exercise was twofold. One, somewhat retrospective, focused to understand why the countries had failed to move to enforcement, but also, more importantly, to see the extent to which we could learn from the experience of India and Pakistan to sort of best utilize this period between adoption and enforcement. And I refer to this as the hiatus stage in the book itself. And I really felt when I was writing it that I was filling several important gaps by focusing on this particular region. Of course, South Asia, there'd been no dedicated study of the South Asian region from a competition law perspective. Whatever extent we had discussions about competition law in South Asia, they were focused on economic outcomes. There was really very little focus on the legal instrument through which these reforms are instituted. We had not looked at the political and legal context in which these countries were engaging in these reforms. It was also a South-South analysis rather than a North-South analysis, but of course there was a North-South-South analysis which I could bring. And I was much more interested, I think, which was also a gap in the success of the law rather than the economic success that it was hoped that it would entail. To me personally, the interesting part of this research and the most interesting, perhaps, contribution of this research is the deliberation, adoption, implementation continuum that it introduces, which is the theoretical framework of this book. And I say interesting because I was drawing upon several different disciplines to develop this framework. So whilst I began with the traditional comparative law theory of legal transplant literature, I also included principles from diffusion and policy transfer, and also from new institutional economics to construct this continuum. So the idea was to be able to examine laws as they move through the deliberation to the enactment stage, and then finally to the implementation stage. And the core hypothesis being that the institutions and mechanisms through which laws were adopted had a profound impact on the manner in which these were implemented in these countries. Comparative law rather could only offer insight into the context. It could really get as far as saying that, yes, context and compatibility are important, but really very little insight into the types of mechanisms that countries can engage in. And for this, I turn to the political science literature of diffusion, policy, and transfer. And then to understand the nature of institutions that can engage in the adoption process and what their impact might be, I turn to new institutional economics. And this is also something I'm happy to expand upon as we go deeper into the discussion. The book was also, or rather is also quite unique in the sense that it examined a lot of primary data, so the antitrust institutions, antitrust decisions of the Competition Commission of India and the Competition Commission of Pakistan, and not only individually, but also comparatively with each other, and also looked at the writ petitions that have been filed before Indian and Pakistani courts challenging these matters. And then there was also an analysis of the general court's decisions in respect of competition matters in the two countries. So just for the major findings of this book, I'm just going to share actually 3 slides, if I may, very quickly. Nilanjan, I know we kept saying 1, but very quickly, 3 slides. So the major findings, the first most important finding is that compatibility, which is touted as one of the most important features, is not enough, but legitimacy also matters. The good news is the legitimacy and compatibility are dynamic. So even if a law is not entirely compatible or enjoys legitimacy at the time of adoption, that can be improved. Both these aspects are generated by bottom-up participatory and inclusive institutions, and both impact the way people respond to and interact with the adopted law. So this was the core sort of theme emerging from the book. I also, of course, sorry, just bear with me a second. Yes, I also had some particular, what is happening? Yeah, so I also compared the total orders issued by CCI and CCP, and I noticed that the country, India, which the competition authority in India, which had started off to a slow start, but had then peaked, and then, and Pakistan started off quite high and then sort of hits rock bottom in 2014, but then, picked it up again. But I think this was a big difference between the two institutions and could largely be attributed by the fact that the Indian law had been socialized a bit more, was better understood in the context for which it was intended. And when Pakistan in 2014 also hit rock bottom, it adopted a strategy of making the law more accessible to the public through advocacy measures. And it was then that we see that the law picked up its enforcement again. In the beginning, of course, it was quite high because they were taking a lot of what we refer to as suo motu actions. Another sort of graph which was quite important was to what extent were the CCI and CCP relying upon foreign materials to make their interpretations. Again, we see a very high reference to foreign materials in the CCP's orders and relatively less explicit reference to foreign materials in CCI's orders. And this could also be traced back to the adoption strategy. Pakistan had, because it had adopted its law through sort of top-down exclusive institutions, there appeared to be rather a need to establish its international legitimacy by invoking very explicitly the its foreign antecedents and making very overt references to foreign authorities as well, which we don't find in India. Of course, this too has, as you can see, is balancing off in 2020. We also see, I won't spend too much time on it, but the penalizing strategies were also quite interesting. And again, we see a large variation between the two countries, and then finally finding some sort of a balance. Another really interesting discussion was about interaction between the competition enforcement systems and the pre-existing systems. So whilst the enforcement system is actually the ones that the law proposes, it's quite linear and neat. You have the NCA order, it goes to the tribunal, goes to the Supreme Court. What we saw in reality was actually the courts getting involved in the inherent writ jurisdiction. In India, the interaction was relatively smoother, at least in its initial years, and of course, regularly sending the matters back to the competition authorities. In Pakistan, we very often saw that matters remain stuck between the High Court and Supreme Court here. And it's only now in 2021, really, that we see the Supreme Court finally beginning to resolve some of these issues. So the final finding was that this hiatus stage, or what we see as the break in enforcement, is not a detrimental situation. It's not a failure, but it is rather an opportunity to take stock. And we see that happening in India at the beginning, 2002 to 2007, there was really no enforcement. That's when India very initially took stock. Pakistan started doing that at a later stage in 2014, when it finally wasn't really able to move forward. It also took stock and recharted its authority, its trajectory of enforcement. And an important aspect of that was the independence of the authority. So the extent to which the authority is independent of the government, it can effectively utilize the stage by engaging in advocacy. And irrespective of whether they had adopted the laws through socialization or through coercion, they had to eventually interact with both the international competition regimes and the domestic context and find a balance. And that really is why these graphs are all sort of meeting towards the end, even though they start off in very different places. And of course, I mean, happy to say that it is an incremental process, and countries were not prisoners of whatever had happened at the adoption stage and could really rechart their trajectories as time went on. So what does that mean then for the region? I think what I've seen is, for instance, that Bangladesh has an independent authority and occasionally sort of makes the right sounds about the need for competition enforcement, but it does need that support from the government, and it also needs to assert itself in its context to have more meaningful enforcement in the region. Other countries have been engaged in different processes, but I hope that this kind of discussion will be of value to them as they just take stock of their situations and think about how they might move from this adoption to enforcement stage and really bring about some meaningful competition reform in their particular contexts. I also hope that other developing countries might find this interesting and be able to adapt this to this study to their own context and see where they're standing in the adoption enforcement continuum and what kind of strategies they may have adopted at the adoption stage and how they may actually tweak them to deliver some results in the enforcement stage. And finally, I think the multilateral agencies should find this of some value, because they are the ones who play a very, very large role in the adoption of competition laws, especially in the emerging economies. I mean, all South Asian countries, I think, were convinced to adopt this law because of the WTO membership. If not the only reason, that was certainly a very, very important factor in the countries adopting competition laws. And I think it's more important that multilateral agencies understand that the manner in which they introduce the laws in the country will have a very big impact on whether these laws translate into some sort of reform or not. So that's all I'll say at this point, and then happy to take more questions.
Thank you very much, Amber. That was brilliant. And yes, 3 graphs were much better than 1. And thank you also very much for sticking to time, because we do want to get as many viewpoints in as we can. And then I hope we'll have a useful and meaningful discussion. I'm now going to invite our first panelist to comment. Dhanendra Kumar was the founding chairperson of Competition Commission of India and is currently chairman of Competition Advisory Services India, COMPAD in India. Mr. Kumar, please speak now. You have about 6 to 8 minutes.
Thank you so much, Nilanjan. First of all, let me thank you and LSE for this kind invitation. It's a pleasure to talk on this forum, share some of my thoughts. Let me also sincerely thank Amber for, first of all, she's an old friend and she was good enough and gracious enough to ask me last year, and she sent me a soft copy of her book to write a few lines for the cover folder of the book. And it was such a privilege. And I went through the book. Oh my God, what a book it was. Once you started it, it was such a racy reading for a competition practitioner or whatever, that one couldn't put it down. And I had all good words for it. It was difficult to condense those words within 50 words which she allowed me to write in. And what I did is that whatever best I could, and I believe those words are there on the cover of the book. So far, I have not seen the book physically, so I hope to see it someday. And those words, then I would see how they have come out. Let me begin some of my comments by saying that in Amber's book, there are 8 countries covered. And I was fortunate when I was executive director in the World Bank on the board of directors. I represented 4 out of those 8 countries: India, Sri Lanka, Bangladesh, and Bhutan. And therefore, I had some idea about the socio-economic conditions of these countries. And therefore, I could relate some of these issues which she wrote in her book to those contexts. Of course, I would also like to add that in none of these countries, the enforcement had begun. I mean, the Act, for example, existed in India from 2002 onwards, but the enforcement did not begin because there was a legal challenge and the Supreme Court had stayed the implementation of the Act. And that brings me to the first point which I wanted to mention. In the slides which Amber mentioned, and very beautiful slides, I would say, compliment her for this. She mentioned about socialization. Indian Act was passed through the Parliament and after debate and everything else, but it also needed judicial scrutiny. And this is another thing which I would say, that the Act was passed, somebody challenged in the Supreme Court, there is no mechanism for review for the appeals and no safety valve. So there has to be a steam valve for this, a judicial outlet for this. And the Act was amended in 2007 and on the observations of the Supreme Court. And what happened that there was a forum which was created, a competition appellate tribunal, to be headed by a Supreme Court judge retired or a Chief Justice of a High Court retired. So a very senior judicial authority, they would man the appellate tribunal. Also, some other amendments were made. For example, the chairperson of the Competition Commission and also the members, they would be appointed on the recommendations of a committee which would be chaired by a sitting Supreme Court judge nominated by the Chief Justice of the Supreme Court of India, which again would ensure neutrality, objectivity, and the rigor. And also the members. So this was another change made, and a few other changes. For the paucity of time, I wouldn't like to go through all the changes. So these are the kind of things which were needed. Also, besides the socialization and democratic acceptance, the judicial acceptance was also something which was important. And this gave legitimacy to the Act. And when I returned from the World Bank in 2009, I was fortunate to have been appointed as the first chairman of the Competition Commission. Through the process, my name was recommended by this committee. Justice Altamash Kabir of the Supreme Court, he was chairing that committee, and my name was recommended. I was appointed by the government. So this is one part. But also after the appointment, I can tell you that we had to undertake intensive advocacy around the country, and India is a large country. I had to go across to all the nooks and corners and talk to the various stakeholders, the industry and the lawyers and others. And it was very useful. And that was also a part of the socialization or democratization, to explain to them what it meant, what was the rationale, and so on. So that is one. And I would also say that my appellate tribunal, it was headed by a Supreme Court judge, Justice Harijit Prasad, who was a famous and a respected judge. Now, he and I went together and addressed the high courts also. So the High Court Bar Association and all the judges of the high courts, they would assemble, and we would talk to them, explain to them what the Act was about and why it was a particular provision existed and so on. So this was another advocacy with the judiciary in the high courts and other courts in order to explain to them what it was about. So I only wanted to say that through a process of socialization during the enactment of the Act and during the enforcement, through the advocacy among all the stakeholders, the industry, the lawyers, and also the judiciary, who would also be involved in this, we were able to involve everyone. Also, in the formulation of the regulations, then it was through a public consultation. Almost all the regulations were posted on the website, comments were invited, intensive consultation were held, and through that process, regulations were formulated. And I thought that this would be another way by which we were able to get people on board. Incidentally, our Competition Act has been intensively amended recently, competition through the Parliament, competition law amendments. And those amendments were also carried out through very intensive discussion in the Parliament, so much so that it was first referred to the Parliamentary Standing Committee, which was headed by a veteran parliamentarian, Mr. Jayant Sinha, and again posted on the website, public comments, this, that, and so on. And finally, it was passed, and now it's an act. And then a number of regulations are being made out of it. And those regulations, again, are being posted on the website, public consultation, and CCI is seized of the matter. And by the way, the emphasis in these amendments is on getting the market corrections, not so much the punishment. I mean, of course, in the digital economy, you have to make certain changes and give certain tools to the CCI, to the competition agency in order to handle the matter, because the characteristics are completely different. Accumulation of data, tipping the market in their favor, very quick accumulation of market power, and so on. Yet at the same time, we had to make sure that the public was fully in the loop and so on. And those regulations are in public domain. And in the market correction, 2 or 3 very important changes which were made, for example, and this is part of the Act. Now the regulations are being made. But one is the settlement and commitment, by which you could get a leniency or lower fine or waiver or whatever it is, if you correct your practices in accordance with, in discussion with the CCI. So settlement and commitment, that is something which has been brought in and which is extremely important. Also, something about deal value threshold. So their idea is that since the emphasis is on data, and many a times, and most of the times, it's not captured in the value, assets or turnover, and therefore the deal value. Just to give you an example, that is.
If we could just be brief.
Yes, I'm just finishing half a minute. For example, the Facebook had acquired WhatsApp for $19 billion, but it was not notified because it passed through the sea. So that's it. And the last point which I wanted to mention is another something for getting market correction, that is leniency plus. So if a group or an enterprise also gave information to the CCI about some other cartel, so in addition to the leniency in that case, they could also get additional leniency and so on. So I would stop here. All that I'm trying to say is that whatever she said in her slides, I would completely support. It comes out in the case of India the way it has done, and emphasis is on market correction. Thank you so much.
Thank you very much, Mr. Kumar. I'm sorry I had to rush you, but I'm sure there will be opportunity later on for you to say a bit more, and there will be questions for sure. I'm now going to invite Dr. Joseph Wilson, who was founding member and then chairman of the Competition Commission of Pakistan, is a barrister and solicitor, and is currently adjunct faculty member at McGill University in Canada. Dr. Wilson, please speak now. You have about 6 to 8 minutes.
Good afternoon. First of all, thank you very much, Dr. Sarkar, for this opportunity, and thank you, Amber. for keeping me in the loop. And I had the opportunity to read the book before. So this is wonderful. Thank you so much.
Sorry,
today,
Mr. Kumar, could you please switch your microphone off?
Today, however, I have some disagreements about what's been stated in the book. And these are 3 points I will just say in the beginning. And one is the legal transplantation of antitrust laws. I think, in my view, competition laws are a poster child for transplantation. And why do I say this? This is an economic law. When I was many years ago, an undergraduate student in studying microeconomics, we used the book of Paul Samuelson, a known economist in the US. The principles were the same for an average consumer: supply and demand, price elasticity, equilibrium. All these things, actually, the average consumer wants to utilize the maximum utility out of its money, out of his, and those principles were applicable irrespective whether this is a consumer in Pakistan, whether that's a consumer in US or UK. Similarly, on the other side of the market are the producers and sellers who want to maximize their profit, and to curb some of those practices, anti-competitive practices. What I see is a universality of competition principles, starting from the Canadian Anti-Combines Act. While there were other laws before, and some states in the US had antitrust laws even before 1889. But let's just start from these federal laws, which are in place. Then come the Sherman Act of 1890. Every contract in restraint of trade. Obviously, this cannot be possible because all contracts put a restraint. It's only in 1911 that the U.S. Supreme Court in Standard Oil versus United said it's unreasonably restrictive competition. Only those agreements that restraint unreasonable. 1942 Parker versus Brown state action defense was first time argued. So this jurisprudence was developed, and if we move forward, the Treaty of Rome, 27 March 1957, has the advantage of jurisprudence, which was developed for 67 years in the United States. And based on that, they revised the laws, which, again, the principles were the same, the competition, the cartelization and abuse of dominance, and so on. So they developed. So when we talk about the model and how do we contextualize that for adoption, is difficult in the case of competition laws, because just as the human psyche, the consumer preferences are the same, the way they behave, if the prices goes up, they will buy less. If the prices go down, they'll not. The consumers all across are the same. The human the producers on the other end also are behaving in the same way. And so we need the same principles, although the syntax could be different, the language could be different. So adopting them could be done without much contextualization. The other term which has been used is the case of coercion. I think this is perhaps a bit harsh to say that a World Bank or any other multilateral agency would have such a force to coerce a state with all its sovereignty and being a nuclear power to do this. So look into that, whether there was in fact a coercion or not. We need to look at the facts, what was happening, and some development in the competition law in Pakistan. So again, briefly, I will stick to my time. The first law we had was the Monopolies and Restricted Trade Practice Ordinance, 1969. Before that, as you stated in the book, there was a 1963 anti-cartel law group was formed to study, because After partition in 1947, there were 20 or 22 families which have a concentration. They had almost 75% of the banking industry, all industrial units were in the hands of these 20 families. So the government was concerned the concentration of economic wealth in the hands of few, and therefore they need to have some laws to restrain that. So the focus of the MRTPO was to prevent concentration of power in the hands of few. Fast forward 72, nationalization, when the law came in 1970, didn't get any opportunity because in 1972, there was a economic reform order, all industries were nationalized. They were ruined for some time, and in 1988, they were denationalized. Now, after denationalization, there comes a period of deregulation and liberalization, 1990s. And with that, you would see that Pakistan Telecommunication Reorganization Act, 1966, the competition principles were mentioned there. PTA shall ensure fair competition in the telecommunications sector exists and is maintained. Section 6E. Oil and Gas Regulatory Authority. The OGRA shall foster competition, increase private investment, ownership in midstream and downstream. Regulation, NEPRA, the authority shall have preference for competition rather than regulation. Electronic media, in granting license, the authority shall ensure that the open and fair competition is facilitated in the operation of more than one media enterprise in any given unit or area of the subject. Provided the licensee owns, controls, operates more than one media enterprise, it shall not indulge in any practice which may impede fair competition and provision of level playing field. So these principles of competition were started to come in these regulated industries, and to talk about the scheme of competition, ignoring these this development is somewhat critical in the book, I find. So move forward. Now, instead of concentration of wealth, we are now in a market where there are foreign players, where the competition principles are being promoted. And here we have a monopoly control authority who has still a law which is focused on the concentration of economic power in the hands of few. And they had difficulties. There was exemption given to a large number of industries. The financial power, the power to penalize was 100,000 rupees, which in 1970s would be around $1,200, and now in present day it will be less than $300. So that was the maximum penalty they can impose, and there was no deterrence. They didn't have the power for a dawn raid, search and seizure. So in 2005 and before, I happened to have an opportunity to become engaged in some of the drafting. And when I met MCA people, they already had drafts of competition law. And instead of adoption, I would call it, to borrow the phrase from Professor Kowalczyk, retooling of competition law. There was not an adoption right away as if there was a barren land. There were all competition laws were there, and they need to retool their powers to fit to the current situation. So to say that there was a coercion is somewhat inapt, because the government itself wanted to have the law. They asked the bank to help to do capacity building. Similarly, because in 1969, it was the federal German Cartel Office and the German Development Agency that helped made the law. So I think that coercion is somewhat incorrect. Now, coming to the findings and slides, there was a mention that there was no order in 2014 is incorrect. There was an order in 2014. It's on the website. And the reason why there were less orders in 2014 and in 1920 as well, no, 21, 22, because the quorum was not complete. The commission was not able to issue an order because they didn't have 3 members in place. That is the reason. Again, there's a statement that there's a use of foreign presidents. I think that's a hallmark of common law to use foreign presidents, and also, and more so when there are no local presidents. It was not there to please any international audience, but it was because of the lack of availability of presidents from within Pakistan. But that said, although the presidents were not used to please, but we did get pat on the back, and to commenting on one of the orders by the Commission. Professor Qaqaya wrote a letter. I have a copy of that because I got a copy of that. He says that I'm delighted to read, it was addressed to the chairman, your commission's recent decision in the Institute of Chartered Accountant of Pakistan. The very persuasively reasoned opinion in this case, finding that the fixing of auditing fee by the Institute of Chartered Accountants of Pakistan violated Pakistan's competition ordinance, is a landmark holding in my opinion. In artfully weaving together interpretations of analogous foreign, American, Canadian, and European case law, the decision paid tribute to the global convergence of views on unacceptability of naked price fixing and to the rejection of self-serving public policy justifications, such as alleged quality or safety concerns for displacing competition. So while we did get the pat on the back from international agencies, it was not to get that pat, it was because of the lack of jurisprudence, competition jurisprudence.
Sure.
So I will rest here.
Thank you.
I thank you again for this opportunity, and I'll be available to comment more.
Thank you very much. And I'm sure we'll be able to come back to some of the things that you have mentioned. May I now invite Hassan Qaqaya, who is an LSE alumnus and is currently senior fellow at the University of Melbourne and was until recently head of UNCTAD Competition and Consumer Policies branch in Geneva. Mr. Qaqaya, please speak now. You have 6 to 8 minutes. Also, if I could kindly request you to either come slightly closer to the camera or to bring your screen closer to you, because you seem, yeah, that's absolutely perfect. Please speak now.
Thank you. Thank you very much, Nizam, for the introduction. Thank you, LSE, for the invitation, and thank you to Amber for inviting and thinking about me, and also for the invitation to participate in this interesting conversation. The first thing I would like to say is that this is a welcome contribution to research on comparative law in the area of competition law, which is very much lacking. So congratulations, Amber, for a great contribution to the work. My comments are of general in the sense that they are not specifically targeted at the cases that we just mentioned, or India or Pakistan, but more about the concept of legal transplant and diffusion, which is the main theme and the analytical framework that Amber uses. It's worth recalling at the outset that competition law is a cocktail of economics and law. And at least if we look at developing countries and the context in which the research has been conducted, I would suggest that the cutoff point would be the 80s and the 90s. So we should leave behind the US experience in the EU in the early stages, because the introduction of competition law and policy in the 80s and 90s was in the context of the Washington Consensus, where the idea was that the free market model is the best solution to generating economic development by promoting economic growth and opening markets, both for trade and regulatory reform within the developing countries. So large of developing countries, whether they were in transition or developing countries themselves, accepted and find themselves in international forums or in dealing with international organizations or research academies, that they were developing countries. meaning that a large segment of their economies relied on, was composed of informal sectors, and the role of the states was an important part, and the whatever nascent or markets were very much in the early stages. So within that context, we see that the competition policy was advocated at all levels, whether it's international cooperation or in the formulation of new development strategies, that it will act as a powerful tool that would not only protect competition in the market, but in many situations would actually create markets and promote markets where they didn't exist as such. So I think this is very important to keep in mind. On competition law itself, as I said earlier, if you look at the principles of the model that has been proposed by international organization, ICNs, etc., you'll see that this is it's a transcription of a free market model based on the principles that free and open markets of free movements of goods and services, both domestic and overseas, small intervention of the state would lead to the most efficient allocation of resources, would generate wealth and prosperity and growth, and through growth, at some stage, development. So we see basically that the competition law, is a legal transcription of an economic model that we're dealing with. Now, clearly, the developing countries were coming from different perspectives, from some centrally planned economies for very low level of development, large sectors of the economy, and clearly transcribing this ideal model of economic principles into law and transplanting it or diffusing it to countries would not necessarily be the same for all countries. One metaphor that is worthwhile mentioning here is if you were looking at a prism, kind of a pyramid, and you see the light going through that pyramid, you will see that although the light will be the same white light at the beginning, the rainbow that cross will give you a variety of all spectrums of lights and different colors. And this is exactly what happened through this diffusion or transplant of competition laws that were based or inspired by models that had experience in jurisprudence in the United States, in Europe, Australia, etc., and Japan, depending on the region which have conduct. But the actual model that landed in a particular country would have a different nuances of colors. And those nuances are the pillars of the prism, depend on a number of factors. And those, at least three corners of this prism. One is, what are the goals of competition law and policy? And many of laws have different, if you look across developing countries and you look at the various laws, you already see the titles are not the same. There are very few countries which have just a competition law. It varies from protection of competition, fight against anti-monopoly, unfair trade practices, etc., etc. So the goals of competition vary from a particular country to another. The second thing is the relationship between business and government in a country, the role of the state vis-a-vis the private sector, and the balance that the two lobby, because there is lobby, there is entrenched interest, and etc., that play an important role in the enforcement, the application of this law. And then the third pillar, which is extremely important, is how the assessment and the balancing of the divergent different interests of societies. Because perhaps the aim of competition policy is to promote growth and promotion of economic private sector, but that growth does not necessarily translate to economic development, which has multifaceted many sectors from health to education, etc., etc. And this the attempt by the various groups to balance this type of corners clearly will translate into different approaches and might explain and contribute in the same way as what Amber was saying. So my take on this is to say that rather than talking just about the competition law or a policy, what is the analytical framework or standard should actually look at the competition regime of a particular country. And that competition regime will be consist of the legislation itself, the organization of the institution that implement that law, whether it's in government, whether it's autonomous, semi-autonomous, whether it has purely competition or have many other functions, consumer protection, IP, etc., etc. The role of the policymakers themselves that work out this, and of course, the expected outcomes and conduct out of businesses. So these, by taking out this multidimensional aspect of what we might call a competition regime, we will perhaps be able to understand and have a better assessment of how different countries have fared during the process of legal transfer to diffusion compared to others, and how the performers have worked themselves. This approach would need to take into account the exogenous factors that act in the process, whether there is the role of international organizations. I mean, WTO, for example, for accession, require developing countries and exceeding countries to adopt a competition law, and it's part. Maybe they are given 4 or 5 years for transition, but it's a requirement as such. Many donor countries also insist or require in the structural adjustment programs or assistance to include competition as part of the regime. But the final adaptation and the final product in terms of law and the policy that is being transplanted in the country depend on, of course, on the sovereign state who will adopt this law. Now, one thing I think that's also very important that worthwhile mentioning here, if you look across the spectrum, you will see that the level of development matters a lot in terms of the impact and enforcement. The more developed a country, in other words, the higher the level of private sector, institutions, education, etc., the easier or the more successful the legal transplant has been in these countries. And you can look across the WC that those countries have done much better where they had well-developed court institutions, private sectors, there's a law, profession, etc. work. Whereas countries with very, very low level of economic development, with meaning very high sector of informal economy, level of poverty, GDP per capita, education, and so on and so forth, you see that the introduction of the transplant of a model that I just mentioned from the 80s and 90s is unlikely to succeed, and is likely to be encountered not only by resistance because it does not meet the objectives of what economic development is there, and whatever growth it generated, it will be concentrated in few sectors rather than others. Let me stop here and leave the time for maybe other questions. But thank you, and congratulations to Amber for this excellent research. Thank you.
Thank you very much. Thank you very much, Mr. Qaqaya. May I now invite our final panelist, Eleanor Fox, who's Walter J. Derenberg Professor Emerita of Trade Regulations at NYU School of Law in New York. Professor Fox, please speak now.
Thank you so much, and thank you to all of the panelists, because I am very honored to be with you at this event. And particularly, congratulations, Amber, for a really provocative book and wonderful to comment on. So I would like to make 4 points. First, on compatibility and legitimacy. Second, on what is the structure for example, socialization and democracy, or coercion at the top for effective competition. And third, I want to talk about just a few words about the use of numbers and statistics for determining effectiveness. And fourth, I want to perhaps join Hassan by asking this question. It's different from Hassan's, but all of his various indicia lead up to it. Is there a South Asian interpretation? Is there a voice of South Asia that we should be thinking of as distinguishing the South Asian competition law? On compatibility and legitimacy, I think it was excellent for you to focus on this. I think both of those indicia are extremely important, that the competition law will not be effective unless there is compatibility generally, both with the institutions, state of development, et cetera, of the country and the country's very particular needs and demands. And secondly, on legitimacy, also extremely important. And as you've said in many places in your book, legitimacy can come, for example, from socialization and participation from the public, so that the public wants this law and believes it satisfies their needs. A second point on legitimacy, which you mentioned, I think more in passing, but you mentioned, is a law can have legitimacy because it is good for the country for external reasons, and it might be very good for the country for reasons of foreign investment. There could be some tensions. For example, the West will say, has said, take our law, it's good for you, and you will get all of our investment if you make the law just like ours. And this, of course, shows the internal tension with compatibility and draws on a lot of what Hassan just said, because it's very interesting that in the 80s and 90s, there was Washington Consensus, and that was also the time when many developing countries were adopting their competition law or new competition law. And the Washington Consensus type law was perhaps as incompatible with the developing countries' economies as there could be. So countries might want to make a bargain and a trade-off in making their law compatible with Western law, as well as very compatible with their own systems. Number two, I was less convinced with what I felt was a proposition that you can have good competition law either with an Indian formulation of socialization and working roots up, or a Pakistani formulation, which you called coercion and top down. And I would say a couple of things about that. I think it may be that coercion is the wrong term because there was an incentive to adopt the law, but the top down versus the roots up is a very interesting dichotomy. The book seems to convey, here are two ways of doing it, and they both can work. I would have thought that it would have been perhaps more interesting and fairer to say that there are a number of circumstances and combinations and country conditions that lead to success, and there are some strong pluses. I would probably not put top down as a strong plus. It could be that a law can succeed in spite of it rather than because of it. But I would say that strong pluses include widespread socialization, strong accountable institutions, strong leadership of the competition authority, political stability, democracy, keeping corruption in check, keeping in check state-owned enterprises and their privileges in crony capitalism, trust in markets, or at least an openness to trusting in the markets, the extent of the trade laws and how protective they are, as well as sensitivity to the country's needs, values, and tolerances. So let me go on to my third point, which is about use, and it involves your slides. It's about use of numbers. I am less satisfied that the numbers tell the story that you want to tell. For example, if during a period of time, India brought a lot of cases and Pakistan brought few. I need to know what are those cases, because I think that we find that many of the cases in India were what some would call fairness cases and distribution cases rather than allocative efficiency cases. And they may have been responding to complaints by competitors who wanted protection from competition. That matters so much that the numbers don't tell a very satisfying story. Now, going on to my last point, I found missing in the book a sense of, was there a South Asian perspective? When you talk about adapting law, talk about transplants are not always good because countries have a very particular climate and culture that is not compatible. So why is that? In other words, I take a little contrary point of view to Joseph Wilson, which I certainly respect that. And I think it's true for part on universality of principles, but I think it's not true for a part also of the uniqueness of principles and needs. And there is something you can say about, for example, what is the voice of US law? What is the voice of EU law? What is the voice of South African law? Even Southeast Asian has at least developed some perspective on use of industrial policy as being different in Southeast Asia than in the West, more industrial policy, less apprehension about using industrial policy. Where on the continuum between, let's say, Washington consensus and South Africa intervention for helping those and bringing into the mainstream those who have been left out, does South Asia lie? So just a final word, I'm very impressed with chapter 9, and I think it might be a launching point for another book, at least another article, at least several seminars. It raises most of the big questions going forward, which I think is great to develop. And these questions are, in effect, how can South Asian competition law be appropriately appreciated by the South Asian people such that they demand it? And number two, how can it be bespoke for South Asia? And just a word to answer, or to give one part of the answer to the first question, showing a community very specifically what the law can do for them, how it can really make lives better off, people better to eat the food on their table, such as, for example, the cost of the Pakistan sugar cartel, which was eventually challenged, showing hard facts about what they're missing in not having enforcement or good enforcement can be very motivating. As for the second, how to find a bespoke law for South Asia, this is what I'd love to hear your comments on it, Amber, and what I would be looking forward to. Thank you.
Thank you so much, Professor Fox. That was absolutely wonderful. And thank you to all the other panelists as well. I can see that Amber already has a list full of things, and we have to give her a chance to respond to at least some, if not all of them, bearing time in mind. But I'm now going to invite Dina Wackett, who has very kindly agreed to be discussant for the panel, and she has a task in front of her now. But Dina Wackett is professor at Sciences Po Law School in Paris, and Dina's expertise includes comparative competition law, antitrust and regulation, amongst several other themes. So Dina, please speak now. You do, of course, as discussant, have the space to give your own comment. So perhaps you might want to start with that.
Great. Thank you very much. Thank you for inviting me to be part of this discussion. I want to start by congratulating Amber for a fascinating book. I agree the book is not only filling a gap in the literature that is highly essential on competition law in East Asian countries. And in that sense, it's really unique in what it does, but it also creates a platform and a typology and a theoretical resource that will be an essential reference to every one of us, and many hopefully out there, that will be looking to think about competition law and policy in developing countries and the global South. So before I open the discussion, I'm using this as an opportunity to give you four short comments, and kick off the discussion with 3 questions. Some have already been mentioned in my fellow panelists here, and then give you, Amber, the floor to react to some or all of these comments. So my first comment is a personal one, and I'll start with that. Reading through your preface about how the role you played in the first cement cartel case in Pakistan and your involvement therein made me think of my exact same involvement with the first Egyptian cartel case back in 2008. And as I was reading through the complications and the unfolding of the story, all I could think about, if we replace Pakistan with Egypt, you could tell the exact same story. So this is in a way, what I'm trying to say here is just an anecdotal way to say that how this book is really at the heart of issues faced by many of these countries in the global south, and it's not just about, although it is about competition law in South Asia, it can be extrapolated to the rest of the developing world. My second comment is about how you frame the success of adopted competition law and its enforcement from the perspective of the host country. I want to highlight how this framing of the assessment in these terms, looking at the host country, is an essential analytical move, and I really appreciate you doing that in the book. It takes a step away from the typical assessment criteria that we usually focus on by looking at how successful in Western terms or how successful in other framing countries are. But here what you do, you include really what happens within the host country using the data. And this really plays out in a way that I think is extremely important to bring through that gap that you're filling in the literature. My third comment is about another analytical move that I think you master throughout the book, namely unpacking the development and transition within competition law adoption and enforcement through this trade-off approach. And you constantly remind us of the importance of this balancing, on the one hand, of domestic legitimacy, but also with these internationally accepted concepts and outcomes. So in a way, you do focus on the host country, but still try to constantly remind us of this balance and how this unfolding of this balancing technique, sometimes successful, but sometimes not so successful, we read a story that really can be extrapolated out beyond the confines of even just competition law and policy, which I think you do really well in the book. My last comment is about your institutional framing. And I think you show us really in a fantastic way how we can look at these different institutional setups that have led to different outcomes. And you take us from the motivation to adopt the law, to the strategy, to the drafting, ultimately to the enforcement or lack thereof. And I think the table that you produce, and for those who have the book, it's table 8.1 on page 215, is a remarkable summary of this continuum that you're trying to show, that I think will be a great typology for others that will try to do the same work. And I think what you remind us here of is that when we adopt this institutional approach, we get to also be enlightened about the deeper institutional understanding and the complexities of how this competition environment, but also the distributional consequences play out. And it allows readers that are maybe unfamiliar with East Asian countries to have a complete and a complex insights into the working of markets, social interactions, and the different political forces. So I thank you for doing that. And I think it's really important to bring that forward. So now I turn to my 3 questions that I hope will kick off the discussion with. And some of them were already mentioned by Professor Fox. In your last chapter, that I agree is the chapter that sort of will, I hope, kick off your next many projects. You deal with the implementation gap specifically. And here you address issues related to the goals of competition and policy. And what you say in the end is that you suggest that at the early stages of enforcement, that the countries that you look at here, but I read that other developing countries in similar stages as well, should prioritize competition advocacy and what you call mainstream competition goals. That, you say, can be expanded later to include other issues that would be important, but you start by saying that's where we should focus first. Now, what I want to hear maybe push you to discuss a bit further is, do you think that this might be a tricky suggestion? It might be a tricky suggestion in the sense that maybe it's always more difficult to change later. right? So this is one part of the issue. Another part of the issue is that today everyone is talking about broadening competition law already, how it is important to include sustainability, climate change, inequality, that are all pressing issues. And there's this sense of urgency. So if we say, well, do mainstream competition goals first and come to these later, maybe that later will be too late. My second question is about what I read as a leitmotif through some of your chapters, which is that notion of growth and development. So this is something that you have at the background, that you keep going back to, and that you bring the reader to follow your argument by showing us that it's desirable to have a an effectively enforced competition law and a healthy competitive environment to promote growth and development. And I can't agree more myself, but I would ask you, how would you square that with current debates that are more centered around notions of degrowth? How is growth still center to the debate? Wouldn't sustainability be something that you would rather approach, integrate, or, and maybe like me, you think that growth is still important, particularly to these countries in the South? And then my very last question, and it brings it back to, I guess, the first three comments that you got, is about the notion of coercion. And here I want you to maybe have a chance to re-articulate what you meant by that. You know my work, and you know that this is something I work within the same framing as well. And here, my original question that I had prepared, that I will modify a bit now, was, do you consider the role of cooperation between South Asian countries as a form of counter-coercion? Could we understand that regional cooperation in this term, but maybe now modifying it after the other panelists have spoken? How do you see the centrality of that notion of coercion to your work? Do you see that we do have to look at it through this framing, or is there an alternative story that's also brewing in the background? And I'll stop here, and I'll give you, Amber, a couple of minutes, and then hopefully we can have other panelists jump in, and then the audience as well. Thank you.
Okay, well, thank you very much. I'm deeply I shouldn't be touched by such extensive comments, but I am, and I'm really grateful for all the focus you've brought to my work, a refocus that you've brought to my work, and the opportunity to talk about some of the core ideas again. Dina, thank you for your very excellent questions. If you let me, I'll begin with coercion, because I think that also answers questions raised by Professor Fox and Professor Wilson. So I think let's begin with that one. So I first want to just talk a little bit about my choice of the word. You know, why did I use coercion? It's not that I haven't had pushback on it already. I have, but there was a reason. There was a very considered reason to use it, which was when I was going through the diffusion and transfer literature, which, you know, at that time was a bit of a novelty, that we were trying to integrate these ideas into a competition law discussion. This was a state-of-the-art term that was used throughout diffusion literature. And one of the things I discovered in my research was that a big factor in diffusion literature not informing comparative law discussions was its vagueness and its usage of different terms for the same idea. Coercion was the term that was most consistently used, and I then very advisedly use the term, and I think I also defend it, as it were, in the book itself. And I say, look, this is a term, it has a specialized meaning in this literature, it captures the essence of what we're trying to say. So what then is coercion? Coercion is not, as we imagine it, and I do too, as somebody, you know, pushing you with a stick to do something, but also that sort of very, which Hassan thankfully reminded me of, that it's also the way the multilateral agencies, you know, include these agendas as part of their assistance programs. And there is this sort of persuasion or a sort of, you know, gentle sort of prodding in that particular direction. So I think when we speak of coercion, it's not really in a very, and I hear Dr. Wilson saying to me, well, we're in Pakistan. I say we as in I'm a Pakistani as well, but, you know, Pakistan being a nuclear power, and how can you talk about coercion? So I just want to respond by saying that coercion is used in a very specialist sense of the word. And it is really used to emphasize the vertical nature of the exercise. And I don't want to go specifically into the Pakistani example, but that's a conversation we can have for later. So coercion is, I think, quite central to the 8 countries that I studied, because with the exception of India, which was also coerced to some extent, which was not, it's just that on balance, it was less coerced than, say, the smaller countries. India was also motivated, maybe motivated is a better word. It was motivated to adopt a competition law because it could see that the WTO is heading in a particular direction. And it was just more proactive, and it established a committee and went to work. Pakistan, on the other hand, I read the minutes of Doha Ministerial Conference, which said, look, we understand we need to have this law. So Dr. Wilson is absolutely right. There was a lot of internal noise, but it wasn't coming to a head. It came to a head with the WTO. It came to a head with the Ministerial Conference, and Pakistan said, we simply lack the capacity to adopt this law. Can you please help us? And then what I call coercion in that particular context is the World Bank sending in a team and then drafting the law. And the pedigree, the sort of lineage, as it were, of the Pakistani law is much more easily traced to the World Bank's ideas rather than to all the domestic work that was going on, even though it was going on. And I do acknowledge some of it, not all of it. I wasn't as aware of all the sectoral work, but certainly some of it. The other countries, a very similar exercise. We have, I have minutes and minutes of Bangladesh at various conferences. Bangladesh resisted the adoption of the law, but eventually gave in. And there we see a soft power, and that, Dina, takes me to the next part of your question about cooperation. What I saw happening in South Asia is really the sort of diffusion of competition ideas from India to the other countries. So what I saw, for instance, is Bhutan, very understandably, Bhutan doesn't have a law, Bhutan has a policy, but heavily influenced by India, drafted by Mr. Vinod Thal, who was the chairperson in the interim sort of the phase of the Indian Competition Act. Bangladesh, heavily informed by those discussions and active engagement. Nepal, heavily informed by those discussions and active engagement. And that's all recorded in the book. So what we see emerging in South Asia, and this is a little bit to answer Professor Fox's very interesting point about a South Asian voice, is that we have 2 sounds coming out of South Asia. One is very much an Indian voice, which is saying, well, these are the sort of state of, the principles, and here let's sort of agree on them, and, this works for us, and we are doing it in a particular way, and several other countries kind of following suit. Pakistan, on the other hand, is not really, it's looking at India, but it's not following India. So that's a different kind of a relationship. So I think there are 2 alternatives that we see emerging. Again, do I see a real cooperation amongst even India, Pakistan, and sort of across the board, talking to each other? I think that's dictated by so many other factors as well. I mean, my hope of a broad-based South Asian cooperation, I have to say, is dampened by political events. They continue to get in the way. But I think that, yes, everybody is looking to each other, and they will continue to look at each other. They will learn from each other. But there is that underlying need for, and this brings me now to your second question, Dina, is growth and development more important, or is there something else that should be informing, is degrowth? And I think if South Asia will agree on anything at all on this issue, it will be that we need growth and development. And we absolutely need to support the South Asian populations to achieve better economic outcomes. Some people, some jurisdictions are more vociferous in that claim. I think Bangladesh has been perhaps, we always sort of think of the bigger countries, we expect them to make greater noise, but I think I was quite impressed actually that was Bangladesh making the biggest, sort of loudest noise in that area. But I think that is really an underlying factor, even though I didn't have enough information to elicit it. I think when I was writing the book, and maybe in retrospect, things become clearer as well, but that is definitely a theme. And that is probably why I wrote the last chapter the way I wrote it, is that if you really want this law to be taken seriously, you as in anybody, all of us, we have to center stage the growth argument and how this law contributes to that argument. Because if we don't center stage it, then we're really falling short on several fronts. And that then brings me in the reverse order then to your final comment, Dina, which was about prioritization. And, I struggle with that because you know a little bit about my work, and you know that I also think about human rights in competition law. And I think about, and I'm very concerned, for instance, about rights of farmers, for instance, in India. And I'm like, what's happening? Is competition good for them or not? But I think for writing this book, I wanted to straitjacket myself and sort of really put myself in the place of a competition authority and say, okay, what can it do? What will it be able to achieve? And I think that given the capacity, and this is again also to Hassan's point, what each developing country has a different capacity, as it were, to bring to bear on its competition enforcement. And given the capacity deficit that we have, not because South Asia is not developed, but also its competition experience is quite limited. It's just emerging into this new field. And we do have an issue. All of these countries, and this is something I also record in the book, all of these countries are emerging from state-owned, sort of state-dominated economies to more, liberal economies. I don't know how far they've moved on that scale, but that is where they are. We have cartels. We have large public sector bodies that, so large organizations, large cartels. They still are very much behaving with the kind of power that they've been accustomed to. So I think that what I will say without perhaps, so what I will say is that, yes, it's absolutely important to have mainstream, what I refer to as mainstream competition enforcement. I think we cannot not have it. And if to have it means that we can't do certain other things, then we won't do other things. Because, and maybe that's too harsh, but I think I'm thinking of several other conversations, which is that if we dilute the goals of competition to include everything else, this is the classic sort of, counter argument that we get, Dina, whenever we talk about including other goals, that, if you try to hit too many targets with a single arrow, you won't hit any. But I think for this particular context, placing myself in the mind frame of a competition authority that is also emerging into its own, that's also battling with a lot of political, sort of obstacles, then yes, please focus on at least getting the basics right. What the future holds, I think if diffusion continues to remain as powerful as I think it is in my study of South Asia, and I think those goals will seep through, and they will start emerging in our competition enforcement. But if we don't focus and get the basics right, then we will have nothing to. We will actually be missing out on the whole idea of economic efficiency, which is so critical. Okay, I'm going to stop with that. So.
Thank you very much, Amber. We don't have much time. We have a little over 5 minutes. And Dina, were you going to say something? I have a question, which is a combination of questions, but I thought I would quickly pose it, Amber, in part because it is connected to the end bit of what you were saying, and also ties up with the point that Eleanor made towards the end about a South Asian voice or not, is I'm going to do this quickly and briefly because we don't have much time, and perhaps then Dr. Wilson and Mr. Kumar could also very briefly comment on it. Is on the one hand, you have the whole question of the incentive to have competition law and the effectiveness of it, or the lack of incentive, the need for it, the benefits of it, etc., etc. And that's the point on which, Amber, you ended. On the other hand is the question of the actual effectiveness of it once it has been adopted and enforced in the two countries, which is Pakistan and India. There are two, there's a sort of a divergent question that emerges from here. One is, if it is really that good and is required and is for the benefit of the people at large, why have the other countries not gone ahead and enforced it? Is it just a matter of there not being capacity, or what? Why is it that the benefits are not being seen by the other countries, apart from India and Pakistan? The other is the question that is about India and Pakistan, which is how effective has it actually been, i.e., how much of it has been, what is the ownership of this law in the wider circuit? So shall we start very briefly with you, Amber, and then perhaps we'll give you the last word once Mr. Kumar and Dr. Wilson have spoken.
So yeah, I think if it is that, your question, if it is that good, why isn't it being used? And I think a large part of it is a misunderstanding of the law. There are two things that I see. I think that there's a misunderstanding on the part of big business. There's a misunderstanding on the part of the government. There is also the power of big business to influence government, to say, well, this law is not going to allow us to achieve the economy of scale that we want, and therefore this is not good for us, which also sometimes makes me think that we are on a, maybe countries are on a competition curve. And this sort of goes back to Hassan's point of the level of development, that maybe for different levels of development, we need simpler laws, perhaps. I think that the way the law is framed, especially in Pakistan, is very, very similar, identical rather to the EU framing, which is any agreement which has the object or effect of distorting competition is going to be caught by this. I think that kind of large framing also terrifies people. So I think there is that misunderstanding, lack of understanding of goals. I think there's also been lack of political will. That's a very, very big issue, which has manifested itself in so many different ways. The lack of quorum that Joseph talked about, that is very much something I talk about in the book also, that this is the way the governments have pushed back on this law. Even when it's coerced and introduced, yes, they have it, but then it is not enforced because there is that lack of political will and doesn't support the enforcement. So I think that is very much at the heart of it. Of course, there are all these other reasons in Pakistan's case, for instance, and a lot of the other countries actually don't have this problem, which is the fact that the law was introduced through an extra parliamentary measure, which led to all sorts of complications later on, but then Pakistan's used to those complications. So I think there are a host of factors, but I think the most important being that we don't really know why this law is there. And because there's never any attempt at educating, or there wasn't really any attempt at educating the public, or at least the businesses when the law was being adopted, the distrust remained for a very, very long time. The second part, has it been effective? I think I would like to think it has been effective. Of course, there are two former chairpersons here of competition authorities, and I think they would probably have more to add, but I would like to think they have been effective. And I think there's, for instance, enough of a competition culture to the extent that companies now know that they need this regulatory compliance, and they need to be aware of this, which is a step forward. Now, if you measure effectiveness only in terms of penalties being recovered, I think that's not the best way to measure it, because penalties are not recovered for many, many reasons. Appeals are good. The right to appeal is absolutely valid. People should have it. And if it is still creating a conversation between the various tiers of competition enforcement, that's still effectiveness. So I would say, yes, it's effective. I think we will see more competition enforcement in the next decade than we saw in the first decade. But I'll let the two chairpersons who are here answer that.
Sure, thank you. I am going to ask them now. We literally have 2 minutes before we end. But Mr. Kumar, you actually made a very, very interesting point at one point when you were speaking about the efforts that you undertook to educate people and businesses and all about, what the law was about and what was, how it was going to work, and what presumably therefore what the benefits of having a law like this was going to be. Outside and beyond the graphs that Amber showed, and with the caveat about the graphs that Eleanor mentioned, i.e. that it's not just about numbers, we also don't know what the content of those cases might have been. Very briefly, in your view, are you, as a former chairperson, are you satisfied, or did you think, do you feel that what's the word? The ownership of competition law in India has been satisfying till now, given especially that, contrary to what Amber said, you said that there has very recently been an intensive amendment of the law, once again, through Parliament. So clearly there is political involvement and will. So, but just very briefly, do you think for the wider public for whose benefit these laws are enacted, has it been satisfying? You need to switch on your mic. You need to switch on your mic.
Right. Now, my only problem is your question took 3 minutes and my time is 1 minute now if you take up to 9 o'clock. Anyway, so when I took over, I mean, people congratulated me, asked me that, oh, good, you got a brand new job. By the way, what do you do? People didn't know what Competition Commission does. So I had to explain them that what they do and all that stuff. But some people from industry said, oh my God, we have another mother-in-law. And I had to tell them that this mother-in-law is a little more affectionate than your normal mother-in-law. And then what are the benefits? And explain to them the benefits which each one of them would have. Protection from big industry, and also in the case of overseas jurisdiction, and so explain the various benefits. So it is extremely important to explain the benefits of competition law to the stakeholders, that it is not only negative, but there are certain positive. You can also recover damages under Section 53N, for example, under the Competition Law of India. So I had to explain various benefits, and even till today, I relinquished charge about 10, 11 years ago. Even till today, I am busy explaining benefits of this in my various public policy forums. So it is important to do that.
Sorry, the question, that's absolutely, that's perfectly made the point and well taken. The question is, are you generally satisfied when you look back at the way in which it has been effective in India, or do you think that given the efforts you had put in, you had hoped more people would take it on? That was the question.
I think I would be extremely satisfied, which is borne out from the various market studies. I mean, the proof of pudding lies in eating. And there have been various market studies have been undertaken by CCI in telecom sector, in pharma sector, in various other sectors. CCI has undertaken intensive market studies, which has shown the market reforms, the corrections, the impact of the competition law. And well, it's a work in progress. And I'm sure in times to come, there would be much better results which would be forthcoming. By the way, I attended a BRICS conference throughout the day today, and some of these issues came up there also. So it's important that the benefits of the competition law are made visible and available to the people.
Thank you. Dr. Wilson, you have the other side of the question to answer, which is you made this point about there not having been a quorum to be able to do the things that were required. The same question is for you in the context of Pakistan, because Pakistan is the only other country that has enforced this. Is what, in your view, could have been done, apart from more political will, to have given greater ownership to this, to competition law in Pakistan and its effectiveness and adoption?
Thank you again, and thank you, Amber, for clarifying question. But I still feel there was an internal need for retooling the law. Coming to Dr. Sarkar, I think the quality of appointments is very essential. You need to bring in people who know what they are doing. Amber did mention in the book that nobody knows what's happening, what is the objective of competition law in her preface. But that is true to some extent. There were people who were appointed and who came to the office and said, what do we do? What is the role of this institution? What is the objective of this organization? So, and one of the reasons from shift to MCA to CCP, the main idea was to ensure that it was not a parking lot for retired bureaucrats. You bring in people who know what they are doing and what they are supposed to do. And unfortunately, it seems to me that it is moving in the same direction over the period of time. So again, I think people who have the skill set to enforce this law is very important, and also not to have a long gap in in appointment so that the quorum is always there. Otherwise, it's quite a loss for the National Exchequer, because people are there, the institution is there, they are getting salaries, but they're not delivering because of the quorum. They cannot take any action. That said, advocacy was an essential tool, and in the beginning, the competition did a lot of advocacy, not only with the Chamber of Commerce, with the public and different, but also with the government on issuing policy notes. And one of the measure of success is whether the consumer has benefited or not. And one is particularly I won't mention and then stop, is the bilateral air services agreement with Saudi Arabia, and with the help of the Commission, that was amended to allow competition in that sector, which reduced the prices of Hajj fares, airfares considerably. And that impact assessment was done, and after 4 years, the prices were the same in terms of dollar terms what was 4 years ago. So there was a considerable benefit to the Pakistani passengers. Thank you so much.
Thank you very much. I'm sorry we're rushing through this, but Amber, I do want to give you one last chance if you would like to respond to any of the other comments that Eleanor made or Hassan made. Not essential, but I do want to give you one last chance.
No, I think I'll let, actually they both have their hands raised, so if you can use that minute to hear from them, and I will pass up this opportunity.
Sure. Shall we start with you, Eleanor? You need to switch on your microphone.
Yes, thank you. I want to support what Amber said towards the end about not including all goals within competition and taking on mainstream and getting basics right. But I want to add to that the world conversation on what is acceptable basics has just expanded so that it's not any longer narrow consumer welfare output limitation. It actually looks more to other dimensions of market power. This is still within mainstream, and looks to the upstream as well as downstream. And therefore, the poor farmers who are exploited in anti-competitive ways can get the benefit of it. And so important to include those, what are the market basics, and to show people what they're missing when competition law is not enforced.
Thank you. Hassan.
Thank you very much. I just to respond to your question that you asked to Kumar. I think as we know, there are two important tools in the portfolio of agencies. One is, of course, enforcement, but the second is advocacy and socialization, as you called it. But it's very important that advocacy and socialization is well designed and well implemented. By that, I mean, it must be evidence-based advocacy. And in order to do that, it's very important not to just target overall advocacy to all kinds of people. The most effective, and I'm drawing on some of the work I've done for Malaysian, which prepared a peer review of its advocacy activities, is that if you target sectors where there are opportunities for reform, for changes, where marginal small changes can make substantial impact on the welfare of consumers, of cost of doing, lowering the cost of doing business, etc. In those situations, whether it's advocacy to regulator, to government, local or central, or to business compliance, the advocacy can be a very powerful tool in demonstrating to the general public and all those who are benefit that actually the law is in their favors and there are concrete results they can be sent at. So yes, advocacy and socialization is important, but it has to be well targeted, selected in areas where there is potential for creating benefits given the underdeveloped market structure in developing countries in general. Thank you.
Thank you very much. I'm afraid we really must stop now because we have sort of overshot time, and this the Zoom link on which we're doing this is also timed. But I do want to first thank Amber and thank all our panelists. Thank you very much for your involvement, for your expertise, for your ideas. And so much of engaged and animated discussion about Amber's book. I'm sure she's very pleased. I do also say this at the end of every event I do an event every week. But I mean it every week, and I mean it as much every week, which is that I think the one good thing that came out of the pandemic is that we all became a bit tech savvy and learned how to use Zoom and do live streaming and things of that sort. What it has enabled small research centers like ours to do is to bring forth these kinds of discussions, which are literally from experts around the globe, for the benefit of the audience. And for that, we are very, very grateful, because we can't do these events unless each of you give your time, your expertise with the kind of generosity that you do. So a very personal and very big thank you to all of you, Amber Darr, Dhanendra Kumar, Joseph Wilson, Hassan Qaqaya, Eleanor Fox, and Dina Wakid. Thank you and goodbye.
And to you,
thank everybody. Thank you so much.
Nilanjan, to you also, big thanks. The way you conducted it, I think it was brilliant. So big thanks to you also.
Yeah.
Thank you, everyone. I will write to the comments I did not respond to. I will send emails. So thank you very much, everybody.
Thank you.
Thank you.